Did you know that you can mediate issues after your divorce has been finalized? I'm Jerry Maggio, California divorce mediator, licensed divorce attorney, and founder of California Divorce Mediators, where we offer an amicable, low-cost way to resolve your case without the need of traditional litigation. In this video, I'm going to explain some of the circumstances where mediation can be a great option after your divorce has been finalized, but circumstances have changed. Number one, child custody and visitation. Sometimes there can be changes after you finalize your divorce where visitation schedules, parenting plans, those type of issues need to be re-examined and modified as needed depending on the circumstances of what has happened in your situation or your ex-partner situation. Number two, child support and alimony, also known as spousal support. Sometimes financial circumstances change once your divorce has been finalized that may necessitate modifying those original orders that you reached in your divorce settlement. That can include somebody losing a job, somebody starting to make substantially more income, which is more relevant for child support modification. But generally, circumstances can change over time where you may need to re-examine and look at what your child support and spousal support obligations are, and perhaps increase them or reduce them depending on what's going on at that point in time. Number three, property division. Yes, you may have worked out a resolution in your divorce case, but there may be circumstances where there are ongoing issues related to perhaps a community business or the marital home or something along those lines, that there may be ongoing disputes and problems with resolving them and finally getting them finalized. They may require parties to re-engage in negotiation and work out an alternative resolution to come up with something that hopefully will then finalize the circumstances once and for all. Number four, communication issues. And what do I mean by that? Well, parents can oftentimes have issues with co-parenting, communicating with their ex-spouse or prior partner, and sometimes mediation is a great opportunity to really work on those circumstances, to come up with better tools for co-parenting, working together for the sake of your children. Number five, modifications to agreements. You may have entered into a divorce judgment, but circumstances may have changed since that time. For example, somebody may have lost a job, somebody may be looking to relocate either to a different part of the state or out of state, or other circumstances that may justify having to look at the circumstances and look at what your prior orders were and sit down and mediate some changes to your original divorce judgment to come up with something that makes sense in light of what the current situation is. You know, it's important to know that if you've reached a post-judgment, post-divorce agreement that modifies the terms of your divorce judgment, it's really important to have someone, that could be done by a divorce mediator, to draft up what your new agreement is into something called a stipulation in order, so that that contains what you've both agreed on to modify the terms of your divorce judgment with new orders. Because if you don't do that, you only have an informal agreement that potentially is not enforceable. If you and your spouse are looking for a more amicable, flexible, and more reasonable way to resolve your divorce case, contact us at California Divorce Mediators and we'll explain what the next steps are. If you like the information on this video, feel free to subscribe to our YouTube channel at the end of this video for more helpful information about divorce and divorce mediation issues. See you next time.